Welcome and good morning, Realtors. My name is Nick Kromitis. I'm CEO of the South Carolina Association of Realtors, and we are extremely glad to be with you here today. Joining me is your SCR General Counsel, Byron King, and our Director of Fair Housing, Tiara Pitts. Thank you for joining us today. We've got a number of interesting topics, at least for us lawyers. They're interesting, and hopefully they'll be interesting for you as well. So this is a Zoom meeting today. It's not a webinar. So we've got, I think, almost close to 500 brokers that have registered for the event. I don't know how many will actually tune in live today, but we are recording, and we will post this on our Facebook and YouTube channels a little bit later. But here are just a couple of ground rules. Please stay muted during the course of our initial presentation and remarks, and at the end, we'll open up the mics for some questions. This isn't our first Zoom rodeo, right? We've done this quite a few times. So when at the appropriate time, raise your hand. Mike will make sure you get recognized. And if you don't feel comfortable speaking, type just something in the chat. I'll be monitoring the chat this morning as well. And if you are having any audio or technical issues, please post some comments in the chat, and we'll do our best to help you out. So let's go. Let's get ready. You guys ready? Let's get started. So here are the topics we're going to cover today. It is going to be like drinking out of a fire hose today. We've got a forms update, legal hotline update, real estate commission license renewals update. Also from the real estate commission, we've got some important staff announcements to make from the commission. The seller disclosure form that's been updated or will be here shortly. A ruling from the commission regarding real estate wholesaling. A fraud alert from Byron, and I'll be providing you with an NAR litigation update and just a brief market outlook, catching you up on some of the news we heard from the meetings in DC just a couple of weeks ago. So Byron, why don't you kick us off?
Thanks, Nick. So the big news is June 13th. So we're inside a month for the update to the SCR 310 and 300. That's the residential resale contract. It's not new language. The due diligence language has been used for about 10 years. But on June 13th, the due diligence will replace the only option on Section 8. So I want to say a thank you to all the years of forms committees and executive committees and boards of directors and the thousands of members in forms classes and forms webinars that have input on this. And if you need a class, the SCR Realtors, Realtors need classes on forms. Austin Smallwood's traveling today, and Tiara and I are available for Zoom or brokerage meetings on the forms. So this will help you negotiate deals. You can focus in on negotiating the deals. Our hotline, kind of our top four are forms and state laws and earnest money and repair procedures. So with this simplified due diligence language, some of you have been using it successfully for many years, but many of you will be changing over to due diligence. It'll make your job simpler. You'll have one deadline. You'll just be negotiating the contract. You won't be haggling over the 9 types of repairs and repair procedure, which if there's a dispute means there has to be a lawyer about the contract and the earnest money. So hopefully the due diligence will make everybody's life simpler. It'll be one deadline, negotiate the deal, avoid the earnest money disputes and the repair procedure disputes that we hear daily on the hotline. And if you have any questions on classes, please contact us on that. And so if you have any questions, you can contact us. The easiest way is to email legal@screaltors.org. And of course,
I'll put it all in the comment.
Got it?
I'll put our email addresses in the chat.
And you'll be talking to Chris Owens, our new hotline operator. Thanks.
All right, Tiara, why don't you give us, wait a minute, before we jump to Tiara, we've updated some of our internal processes with the hotline. Byron, why don't you tell the group about how we're kind of tracking and monitoring legal hotline calls?
Yeah, definitely. So what we've done is we have 4 attorneys on staff. So you got CEO Nick Kromitis, attorney Tiara Pitts, attorney Austin Smallwood, who's traveling on forms classes this week, and attorney myself, Byron. So to make sure you can always get a hold of us, like I said, we have a new in-house phone operator, Chris Owens. We had been using an outside service. And we also have a service that Alan Lightly and Michael Chris set up called Zoho Desk, where when you contact the hotline, you'll get a ticket, and there'll be a ticket number, and Chris Owens will take your information, your contact information, your membership information. All the attorneys will have access to that. So the first attorney on deck to return your calls. Hopefully it'll speed things up. It'll enable us to track hotlines, how many we're getting, what time of day, and the customer service is
Just a reminder, make sure everybody stays muted on the calls. I appreciate that very much. So Tiara, let's jump into some real estate commission news.
Yes, so June 30th is the date for license renewals, which is fastly approaching. And I know you guys are probably busy with the summer, closing a lot of deals, but we want to make sure that that's one of your priorities. And there will be a large LLR staff turnover. One of Rod Atkins is one of the people that will be leaving the real estate commission along with other staff there. So it may be a potential for things not to go as smoothly as before, just due to the turnover and then finding new staff. So we want to make sure that if you have to renew by that June 30th date, that you're going ahead and doing the proper renewal process. And one of those things includes fingerprinting, which is fairly new, and it is used as a safeguard for safety and anti-crime, because you guys know as realtors, you have a lot of interaction with the public, and you're going into homes, sometimes driving people in cars, and we just want to ensure a heightened standard of safety for our membership and for members of the public. So that fingerprinting will help to do that and to perform some of those background checks. And the company that will be doing those fingerprinting is called Identico, which is contracted through LLR. And even if Identico is short on appointments before that June 30th date, we advise you to go ahead and have it scheduled so that you can still renew your license, but maybe if you can't get it before June 30th, that you'll at least have a standing appointment, and you can work that out with LLR to make sure you're staying on top of that. And just so you know, the new fingerprinting process, the database is a standalone database. What that means is if you've had fingerprinting previously, I know I have to get my law license, maybe for TSA pre-check or insurance, or even your concealed weapons license or the military, any of those different ways you may have previously had a fingerprint does not count towards this system because it is a separate database. There's no system that combines all of those fingerprints and allows us to easily share that information. So you will have to get a new fingerprint, even if you have it on file for something previously.
Tiara, those fingerprints are really it's a snapshot in time, right? When you're applying for that license, they're looking at your history at that moment, and it's not something they keep on file, which is why every third license renewal term you have to go do that again, right?
Right.
So it's a preventative measure to try to capture those potential bad actors that are trying to get into our business for the wrong reasons.
Exactly. Yep. So that is, and if you have any questions about the fingerprinting process, sometimes the fingerprint doesn't go through on the first time. Any questions like that, you can just contact us at the legal hotline we can put you in contact with someone from LLR and help you with that if you are having any trouble, and if it's not an Identico in your area. Most areas has one, so that shouldn't be that much of a problem, but it is a small percentage of places that may not have, it may not be one very close by. Also, another change with LLR is on July 1st, our property disclosure statement is going to be updated. But the primary change is that buyers must look at off-site issues, including agricultural issues like poultry, hogs, cattle, and farming. And what that means is the purchaser is responsible for conducting their own off-site conditions to see if any off-site conditions are going to affect the property and do those inspections. The real estate licensee has no duty to inspect those off-site or on-site conditions. So that puts the duty on the purchaser, but we want you guys to know to make sure your clients are informed of everything that they need to be inspecting prior to purchasing a home, and making sure that property disclosure statement is filled out to the best of their knowledge.
I think what some background on that is that we can talk about. the farming community, the Farm Bureau has been under pressure from development in different areas of the state, right? And what's happening is you've got residential development kind of butting up to farming operations, and with farms there are what, there are noises, there are smells, there are lots of things that go on with farming operations, and South Carolina is a right to farm state, and we wanted to make sure that buyers and sellers, particularly buyers, were aware of these conditions, and that if it's important to them, that they make sure that they investigate it and check it out for themselves.
Yes, thank you. So yes, always be investigating these things, and now it is actually written on to our property disclosure statement, and that will be updated on July 1st. But that new form is available for you to view. It's not much changes. That major change is just look at those off-site issues, such as Nick mentioned with the farming and things like hogs and cattle could make certain smells in the area or affect something off-site. So we want to make sure you guys are looking at that. And next up, there has been a lot of conversation about wholesaling. I'm sure you guys have heard about this. We get hotline calls and different things. But if you aren't familiar with what that term refers to, wholesaling is when a company or an individual enters into an assignable contract to purchase a home from an owner, and then they market that home to the public without actually having any ownership. So they're being basically a person in the middle of a transaction. They have a deal with the owner to market it, and then they find a buyer. But the issue is that the wholesaler doesn't have that ownership as you would if you are a normal seller who's just working with the real estate agent. You have your ownership. It's not those problems. However, with wholesaling, the commission has interpreted this situation as the advertising of real property that belongs to another person with the promise of compensation, which is which falls into the definition of a broker with our SC code 405730/3, but I don't have to give you guys specifics. But basically what that means is it requires a license for you to be selling or advertising property in the hopes of getting compensation for it. And with wholesaling, or AKA flipping, it requires a listing brokerage to advertise that equitable interest. So what the Real Estate Commission is basically saying is that people who are conducting business in this manner, whether you want to call it wholesaling or investor or flipper, that they would need to have a valid contract with a valid listing agreement with a brokerage in order to advertise that property to the public and advertise their equitable ownership without potentially violating South Carolina license law. And this is fairly new. And of course, we'll be updating and monitoring the situation for any changes and keeping you guys updated. But it is a potential violation of license law if someone is acting in the way that a broker or licensee, the duties that they perform without having those proper licenses or without having an agreement with a brokerage. And LLR has stated in their recent May newsletter that they'll accept complaints for this type of violation, and that they will send cease and desist letters to people, these wholesalers or flippers, investors who advertise without having a valid listing agreement. And we can expand on that a little bit more if you guys have something to add.
Thank you. Thank you, Tiara. Yeah, the wholesaling thing is kind of a bombshell announcement from the commission. And we're all aware, I think we've all seen these companies in our communities. Oftentimes, they're legitimate businesses, but sometimes they're also preying on those vulnerable homeowners that are in desperate positions, and they're literally trying to take whatever equity they can out of these homes. And we applaud the commission for taking a firm stand on this, and we will continue to update you. And we encourage you to, if you see these businesses operating without proper licensure, turn them in, let us know, and we'll report them to the Real Estate Commission. So keep posting your questions in the chat. I'm going to save all of these up and we're going to get to them at the Q&A. But let's move on to our next topic. I know we've hit you with a flurry of them here. So next we've got a little bit of a fraud alert with Byron.
Thanks, Nick. So NAR has alerted us, and Nick's taken calls about the fraudulent insurance calls. We've been getting calls about fraudulent credit cards being opened to people's names. So we recommend that you monitor your credit, maybe even hire a monitoring service, that you lock your credit. You can now do that with a smartphone app, like example Experian, where you can turn your credit lock on and off with just a press of your thumb. And so just be aware that cybercrime is one of the top issues that we're seeing on the hotline, and NAR is reported as one of the top issues nationally. And Nick, you said you've gotten some calls about fraudulent insurance.
Yeah, I'm sure you have received these calls. I'm sure, because I know I have on my cell phone, and I've seen the chat on social media where members have accused NAR of selling mailing lists and things like that. I can guarantee you, assure you that NAR has not done anything of the kind. And NAR sent out a couple of updates on the topic, but there are ways to block spam calls on your phone. But these telemarketers are persistent is I think being kind, and where NAR is certainly aware of the situation. Unfortunately, there's not a whole lot we can do other than report it to the FTC, but it has not slowed down. So please let your agents know that they're expressing concerns over these telemarketing calls. It is not your association that has generated those. So just a FYI. So let's switch gears one more time, and let's talk about something that I think is very important to all of us. There is a lot of news lately about some of the class action lawsuits that have been taking place across the country, and it's important to be aware, to stay on top of these cases, because in a worst case scenario, these cases could have an impact on the way we do business here in South Carolina. And I'll tell you why South Carolina is a little different than some of the other states in the country and how these lawsuits may impact us. But let me give you a little background just to catch you up on where we've come from with these and where we are. So in 2019, NAR and 4 corporate defendants were sued in class action lawsuits filed in Missouri and Illinois, alleging that home sellers have been damaged because their listing broker compensates the buyer representation. Y'all are familiar with that process. These lawsuits allege that various NAR rules and our members' adherence to those rules have led to artificially fixed and inflated commissions being paid to the real estate professionals. That's where these class action attorneys have come in and see an opportunity for a big payday on their behalf and their clients' behalf. Class action litigation, as you know, is a very long and arduous process, and NAR has been keeping us abreast of the news and updates, which have been very slow to come over the last 3 years. But we need, NAR is asking us for our help, because part of what we're dealing with is not only the opinion of our courts, but also the court of public opinion. So just a couple of weeks ago, the federal judge in the Missouri case granted class action certification. Now, this is not a victory for the plaintiffs, but it isn't good news either in that regard. But it does not, the decision to grant the class certification is not a ruling on the merits. The judge wasn't declaring that this case was a good case or a bad case. It just met the standards for class certification. Now, the ruling is only procedural and now allows others that have been allegedly impacted to join the litigation as plaintiffs. NAR is appealing that decision. Again, this is going to be a very lengthy process. NAR obviously was disappointed with the decision. NAR continues to believe that the pro-competitive, pro-consumer local broker marketplaces serve the best interests of buyers and sellers, particularly sellers making offers of compensation to buyer brokers also give first-time, low and middle income, and all home buyers a better shot of achieving home ownership, of affording a home, and having proper representation. And that really is, for me, kind of the hook where all of these cases hang on is the public policy argument. Are buyers better served by having representation in the single transaction that will probably be the largest investment they ever make in their lives? Or are they better off without representation? I think we all would agree that a model that allows for buyers to have representation is in the public's best interest and in buyers' best interest. NAR is asking for our help. They've launched a website called competition.realtor. They want us to share, not only with the public, but with our own members, the value that realtors bring to the table. And we're going to encourage, you'll see more news posted about how you can participate in that and how you can share that information with our members and with the public. You know, a lot of states don't require buyer agency agreements. South Carolina does by law. So in a sense, a lot of what they're claiming doesn't necessarily apply to South Carolina, but it could impact NAR policy down the road, which would also affect us as well. And one other piece of news from the antitrust litigation area, last week, the Ninth Circuit Court of Appeals reversed a lower court's decision granting NAR's motion to dismiss a lawsuit challenging the clear cooperation policy. This is the MLS policy, as y'all may recall, that requires listings once they're advertised to the public to be placed within the MLS within 24 hours. This case was initially dismissed. NAR believes the clear cooperation policy is pro competition and pro-consumer, and will continue to affect the defense and of these litigated cases. Oh, well, I do have one last bit of actually good news. There was another class action filed on the East Coast, the Leader case. This time, the Leader case was a class action lawsuit that was filed on behalf of buyers claiming they were harmed by the rule where listing brokers offer compensation to buyer representatives. I'm pleased to report that as of, I think this was last week, the U.S. District Court judge dismissed the case, and it's unlikely that this will go forward. So that was a big win for consumers and our members alike. So before we get into the Q&A, just a couple of market issues that I wanted to share with you. Over the last few weeks, we've started to see some change in activity around the state. But as you know, as leaders in your markets, it's important to keep these numbers in perspective. Sales may be down about 8% year over year, but if you look back to pre-pandemic numbers, 2018, 19, and early 2020, we're still on track on that same kind of trajectory that we were minus the weird bump of the pandemic. It's important that we recognize that inflation, housing valuation increases, market supply issues are going to continue to affect our market. And I've talked a couple times this week about shifting during this process. Half of our members have only had a license for about 5 years. And let me put those numbers in perspective. There are almost 28,000 realtor licensees, 38,000 general licensees. 28,000 of those are realtor members. First time ever that more than half of the population is made up of realtor members. Our members do about 90% of the business statewide. But these numbers are going to impact our activity and normalize our real estate sales. And as market leaders, it's important to stay ahead of those shifting patterns so that you're prepared. The vast majority of our members have never done a short sale, never done a foreclosure. And while I don't think we'll see anything near the level of what we saw in 08 and 09 and 2010, I do think we'll see a small spike in that foreclosure activity. The good news is because we're so low on inventory, because the market demand is still very, very high, interest rates are still relatively low, any foreclosure activity I would expect to get kind of swallowed up in the marketplace, absorbed very quickly without creating a glut, without creating pricing issues. Fannie Mae is suggesting that we'll probably have a kind of a soft landing, a moderate recession, maybe starting at the end of next year. Our national economist tends to agree with those numbers, but I think our national economist has said that it won't be led by housing because of our fundamentals are just a lot stronger than they were a few years ago. One interesting note, I was reading earlier this week that Wells Fargo has laid off a few of their mortgage origination people, about 400 or so. One of those markets where they conducted some of those layoffs were in the Charlotte market. So that's kind of close to home. And as I was preparing for this today, I remember I pulled up some articles from 07 and 08 where Wells Fargo and others were laying off tens of thousands of mortgage origination folks. Quite a stark contrast to this time, the last time to this time. Earlier this week, the president and the administration announced a housing plan to address the lack of affordable housing and the lack of inventory in this country. It's on initial read, it's promising. I'm not sure that it does nearly enough. Definitely like the kind of the carrot approach that they bring to it. NAR is going to have an update for us on that as well. Look for that in your inbox in the coming days. I will ask Mike to link the Lawrence Yoon residential and commercial update presentations that he gave at the conference a couple of weeks ago, where he estimated pretty strong outlook, pretty positive outlook for the next, at least through the end of 23. So we'll put those in the comments and in the chat here in just a second. And just looking at my notes, I think Byron, let's go into the Q&A. But first, why don't you give us a quick antitrust disclaimer?
Right, this wouldn't be a good legal seminar without the lawyer disclaimer. So a couple things, this legal information is only good today, May 18th, 2022. Call the legal hotline, contact your attorney. And antitrust, Nick talked about competition. You're all competitors, even though you cooperate on deals, you're competitors. That means U.S. Department of Justice issues for antitrust in the chat or these questions. So we're not going to be talking about boycotting anybody. We're not going to be talking about any price fixing such as commissions or business models.
Great. All right, so let's do this first. I'm going to go and answer the questions that are in the chat, and then we'll open up the mics for anyone who wants to jump in. So the first question we have is in regards to the updated seller disclosure form. And the question is, does the new disclosure form need to be updated on listings, or does it apply only to new listings going forward?
So that would apply to listings starting July 1st. It wouldn't apply retroactively to previous listings, which is why they still have both of those listing agreements up, but they have the date that this one will go active, the new one July 1st, and it has the date the previous one was active. So anything July 1st is when you would use the new residential property disclosure statement. And before that, if you already have deals and already use that previous one, then you're okay to continue with that.
Yeah, the only thing I would add is if you're renewing an existing listing after July 1st, make sure you get the new form attached to it as well. Cool. All right, so next question has to do with wholesaling and flipping. The question is, are you referring to the general public doing flipping or wholesaling? Byron, did the commission make any distinction about whether the wholesaler was an individual or a company?
Right, so this was a huge newsletter from the LLR, the Real Estate Commission. They basically have said that wholesaling without using a broker, if you're advertising, you can be found in violation of South Carolina license law. So for a wholesaler, if they're a company, if they have an LLC, or if they're an individual, you'd obviously tell them to talk to their attorney, but keep in mind under this real estate commission order that they can cure it. They can still do what they're doing. They just need to hire a listing broker to advertise.
Gotcha. Yeah, it is something we'll need your help to report. If you see these activities in your communities, please let us know. So the next question is a good one. How do we stop the healthcare insurance companies from texting us and saying they got our name from NAR? I wish I had a good answer. If you use iPhone or an Android device, there are spam blocking tools that you can employ. You can certainly block numbers. And there is a place where you can report those to the FTC, and we'll make sure we include that in a follow-up email to the group. So another chat message here says, what actual consequences will wholesalers face because a cease and desist letter doesn't sound very serious? Well, if a company fails to comply with a cease and desist, they could be held in contempt, right? And they could face civil and possibly criminal charges as well. So there are consequences that would follow up. Hopefully a cease and desist would suffice, but unfortunately there may be some that choose to fight the system, so to speak. And there are other tools the commission can employ to knock down on those businesses.
Because the public policies to protect the public, right? So we've been getting a lot of really frightening looking documents on some wholesale deals that realtors haven't been involved with. So it's probably time for the real estate commission to take some action.
Good. So I got another question. When is the economist thinking the soft recession to begin? Fannie Mae put out a press release, like I said, about 10 days ago. They were expecting a modest recession in the third or fourth quarter of 2023. But again, that's a prediction. And one of the things that we have to be careful about as realtors, you know, obviously we're not economists, we're lawyers, and you are experts in the real estate industry. You know, sometimes if we talk about something enough, we can create, we can make it come to life. We need to continue to make hay while the sun shines, so to speak. This market that we're in is driven by a very high demand, driven by the high quality of life that we have in South Carolina. And we don't need to be our own wet blankets when we talk about economic conditions. We know what South Carolina offers. You know that 5%, 6%, even 7% interest rates are good compared to what we've seen in the past. And we will continue to transact and do business as long as the economy allows that to continue. Real estate is cyclical. As I mentioned, a lot of our members haven't had that long-term experience. And we have been on a 12-year run, which is unprecedented for South Carolina and the rest of the country. So just stay positive, stay on top of the trends, and be ready to pivot when and if necessary. But don't be the Debbie Downers out there in the market and predicting gloom and doom, because if you predicted it, it'll probably happen. So next question, we've got a question asking about what is going on with the Clear Cooperation lawsuit again. Just really quickly, there was a lawsuit out of California that had challenged NAR's Clear Cooperation rule, and that was originally dismissed by that federal judge. That the plaintiffs appealed that decision, and the case has been reversed. The dismissal was reversed, and NAR is now appealing that decision. So nothing significant has changed regarding Clear Cooperation, but other than that the case is still technically alive. So we've got another question. It says, we drill into our agents not to write language on addendums or contracts. Will SCR Legal write or review language for agents to use when creating or negotiating offers. Jim, I would love to be able to do that. We have 28,000 realtors. And unfortunately, with 3 staff attorneys that are manning the legal hotline, we would be busy writing contracts all day long. Yeah.
We were talking about that earlier with a possible way could be how we were saying they could go to their attorney, or if the wholesaler that you're trying to work with, if they're familiar in the business and they've been doing this, then they probably have a closing attorney that they work with who could draft the proper documentation, since we don't currently have any forms that would relate to this wholesaling situation because it's fairly new. But it's definitely something I'm going to talk to Austin about to see if the forms committee would be interested in doing any type of forms around wholesaling.
Yeah, I don't think this question was specific to wholesaling.
Oh,
I just
okay.
think kind of general language provisions.
Yeah, so some things I'd bring up, a lot of brokers aren't aware, we've also got a Form 391. So Form 391 is probably about 15 common phrases that you check box. So if you never use Form 391, we've covered a lot of the hotlines, and we get hotlines and brokers want to add language to the contract. We've covered most of those in Form 391. So take a look at that. The other thing is due diligence is going to help a lot with this, because you won't have to negotiate on the offer, right? Because due diligence basically covers everything. You'll agree on a period for due diligence to look at the property on site and off site, like Tiara was talking about with agricultural. And also it helps the seller because the seller will get a due diligence termination fee if the buyer walks. So the due diligence will help on this. Form 391 will help a lot. Forms committee looked at escalation clauses and decided not to make a standard escalation clause, but like Tiara was talking about, you can always hire your own attorneys. Most of your closing attorneys would be happy to help you out with some language.
Yeah, and as a general answer, Jim, we're happy to review contracts and agreements that come into the office, but actually drafting clauses and things that are not in our standard forms, it would be, we just don't have the manpower to do that. So thanks for your question. A couple of questions here about wholesalers, actually several questions about wholesalers. Has to do with one question about regarding advertising. Does advertising include letters to owners? I think that would qualify as advertising. Can a wholesaler operate if they are not advertising? The answer is still would be no. I don't think it's strictly limited to advertising, but that's the kind of the hook that the commission is using to drag them in. If they are in the business of real estate, it's my opinion, they need to be licensed, period. If they are holding themselves out to the public through, it could be just a business office sign, that's advertising. If those directional signs, you've seen them everywhere, you know, that's holding yourself out to the public. If you're an individual investor and you're doing it for your own profit, for your own business, that's a different matter. But if you are in the business and holding yourself out to the public, you need to be licensed. So a question comes in, Beth asks, how could we list a property with a wholesaler and pay them when they aren't a party to the transaction? The listing agreement needs to be with the seller owner of the property, not the wholesaler, correct? That is the position the Real Estate Commission has taken, right, Byron?
Right. So what we say on the hotline, Tiara touched on it earlier. If you have a wholesaler that does a lot of these, they probably already have a law firm that they work with, and that law firm can help you develop forms for, you know, listing a wholesale flip or handling the transaction. Right now, our standard forms do not have wholesale documents in there, so you would need to have a private attorney draw that up.
Good. Another question's come in regarding kind of the hot market that we're in. It says the question is, in this market, the buyer having to go to their attorney to write basic legal language for an offer they may not get, and having to get a personal relationship with an attorney who will work with them over the phone instead of having to make an appointment. These are things we are hearing from our buyers. Are we allowed to write addendums with bullet points?
I would say, I would like to find out what you guys are wanting to add to contracts. So as we try to add on that Form 391, we try to add the ones we hear over and over on the hotline, and due diligence is going to carry those. So if you can put in the comments some of the things that you want added into Form 391 or the use a lot, but on the hotline, I don't hear a lot of callers saying, hey, I want to add this, and I can't say it's already in Form 504, Form 391.
And to be very specific about your question about, are we allowed to write addendums with bullet points? It's absolutely not. That would constitute, trigger a UPL action, unauthorized practice of law action, and could get you in a lot of trouble, including
Lawsuits, Article 13 of the Realtor Code of Ethics, felony crime, arrest, put you in jail, lawsuits.
and that is not stretching it, right? We have actually seen a real estate agent jailed, put in jail for a UPL action. Beth asks, can we post a link to the new property disclosure form? Is that on the Real Estate Commission website, Tiara?
Yes, that is on the Real Estate Commission's website, and Mike is also adding it to the chat. And I think Matthew has added it to the chat as well. And you can find that on the forms on the Real Estate Commission's website, where you find the agency disclosure and other forms that you guys use.
We'll make sure that we add it to our website, and it'll be in all of our form vendors, Zip Forms, DocuSign, Dotloop, and others as of July 1st.
Yes.
Okay. Excuse me. Leanne asked, how do we turn in wholesalers for unlicensed actions? You can report those directly to the Real Estate Commission. There's an online process for filing a complaint, or you can email one of us with the information. A picture or two would be helpful, and we can report that to the commission for you as well.
And just so you guys know, we can't take the complaints through our code of ethics process here at SCR, but we can, LLR takes those complaints and we can put you in contact with them or go ahead and give them the information on your behalf. But just as far as our jurisdiction, since they aren't technically licensed, they aren't realtors, we wouldn't have that jurisdiction over them to handle it through our complaint system. But LLR system, which is similar but more expansive because they actually cover your licensing, would be able to handle complaints of that nature.
Thank you, Tiara. The last one we've got in the chat, Byron, I think I'll throw this one to you. Cynthia asked, what is the true use of the general addendum?
So the general addendum is the Form 390. And I get this on the hotline a lot because realtors are like, hey, Byron, you're telling me I can't add things to the contract. I can't write phrases or sentences, but yet you give me a Form 390 with a bunch of blank lines. You can't, but your closing attorney, your buyer's closing attorney can add to Form 390. So 390 is for an attorney to add that. It's a standard form. So your attorney would basically approve whatever language you want to add. And if you can email us some of these phrases that you want to add, we can add those to 391 if they come up a lot. But in my opinion, based on hotline calls, we've added a bunch to 391 into 504. So I think we've got most of the ones covered. There may be some unusual ones that we can look at adding.
Awesome. I know the realtors that are watching today, y'all can't see this, but on the wall over here, we've got our Zoom TV with the big grid. We can see Vicky and Laura and everybody on the screen over here. It's great to see y'all. And the chat's coming up on the screen. This is pretty high tech. I'm pretty excited about what we've got working here today. So I think we've answered everything that's in the chat. Anyone want to raise their hand and ask a live question? Matthew looks like he's thinking real hard over there.
I see a question. Are we able to add clauses to an addendum if they have been drafted by an attorney? Yes, that's the best way to do it, to protect yourself and your clients.
Mike, do you see any hands raised in the group?
Somebody please ask her questions when we test the technology.
Matthew, unmute your microphone. Let's see if I want to see if we can hear you.
Yeah, so you mentioned the Forms Committee, which I have the honor and blessing to be on, and you mentioned escalation clauses. Have you guys received any requests to add appraisal gap language in there? I haven't heard anything on the Forms Committee about that, but that's been a big issue here over the past several months.
That's a good example because I've had that on the hotline. We can definitely send that to Forms Committee. One
issue that I was speaking to Charleston Top Producer Club yesterday, and we talked a lot about some copyright issues. Just as a reminder, photographs that your agents see on the MLS are not, it's not open source information that they can just grab and recreate flyers and whatnot. They need to make sure you've got permission from the photographers. I'm sure y'all are on top of those issues. We're also starting to see home inspection reports being copyrighted and being protected as intellectual property. Please read the disclaimers and the materials on your home inspection reports to make sure that you're protecting any rights that the home inspector has vested and making sure that the buyer, even though they may be giving that inspection report to the seller or the listing agent, making sure that they've got the appropriate authorization and permission to do so.
One thing to add on that, Nick, we also, NAR has given us some licensing agreements. So you can cure some of these issues about copyright. You can get a license to use photographs. You can expand the license with a home inspector to use their home inspection because you're paying for it. So you've got the leverage when you're ordering.
Yep. Couple of questions in the chat that have popped up. Can you start using the property disclosure now? Sure. There's no reason why you can't start using it now. It's got all the old questions in it, plus a couple of new ones. So there's no reason why you can't start using that now. Is there a link to the decision for the wholesale issue? It is on the Real Estate Commission's website. It's their recent newsletter. If you receive our weekly emails, at the very bottom of all of our emails, we have a link to the Commission newsletter website. And Mike, I'll ask Mike to go ahead and put it in the chat now so that you can have it handy. But we publish that every week in our weekly emails. So we've got some suggestions for some addendums, Byron. So we'll, if property is rented long-term, short-term, due diligence fee, appraisal gap, new construction, some great ideas. Jim, thank you for sharing those. Is there any chance of a Vacation Rental Act disclosure? I do know, Penny, that there is going to be a few committee meetings this summer. Representative Lee Hewitt from the coast and others have had an interest in updating the Vacation Rental Disclosure Act. So I think there will be some possible suggestions for changes going forward. But if you could clarify exactly what you mean by if there's any chance of a Vacation Rental Disclosure Act.
Right. So on the hotline, we've gotten this call. So under Vacation Rental Act, as you guys know, you have to disclose, vacation rentals going out past the closing for the 90 days. And also the property manager. So on the hotline, typically I'll tell them just put it in a document, a Word doc, a Google doc. But I can pass that on to forms. Maybe they can make a standard form to disclose reservations and the property manager contacting.
Yeah. Marshall says that LLR is going to need more manpower to help oversee the wholesalers. And that's without a doubt, Marshall. I think you're right. As you heard Tiara tell us earlier, the Real Estate Commission is losing 3 key staff people, including the administrator, Rod Atkinson, who's been such a pleasure to work with over the last few years. He has been a tremendous asset for the commission. He's going to be sorely missed. And as we approach a very important renewal cycle, it is going to create a hardship. There are probably going to be times where your agents see delays in that renewal process. Please ask them to be patient and understand that the commission staff is going to be understaffed probably for the next 2 or 3 months. Their hiring processes aren't like a regular business. It's a government agency, and they've got to jump through a lot of hoops to get all of those positions filled.
Should we mention the position that we posted in the newsletter?
Yeah, the administrator's position has been posted. We shared the job description in our newsletter. If you know of any candidates that would be interested in a career at the Real Estate Commission, it's a good opportunity to explore that. So please check that out. So Mike's posted the newsletter link. Cynthia asks if we can have a lots and land property disclosure. So that's another great suggestion.
One thing.
Yeah,
One thing I say on the hotline of the land disclosure, because we don't have one. I've seen other states that do, and all the questions on those other states are inside the current SCR 230, the residential disclosure. So my recommendation right now is to use that SCR 230 in all your transactions, because it does give you liability protection in the statute and case law.
yeah. Jim asks if we get addendums drafted by our attorney, can we share with our agents and use those within our company? I think the answer generally is yes. If an addendum is drafted for a specific set of circumstances, if it's unique to a particular transaction, you may want to be careful kind of using that as a general course or general provision in other contracts. But generally, the answer would be yes. Attorney drafted, attorney reviewed is good for the whole company.
And I would tell the attorney, say, hey, we plan on doing this over and over. Make sure the attorney's aware of what you're doing. Because like Nick said, if it's fact specific, that transaction, it might not be useful in a future transaction.
So Ben asks, off topic, he asks if we can speak to any South Carolina law that overrides HOA restrictions for real estate signs. Ben, you have hit a sore subject with me. I believe that a lot of these HOAs overreach in their sign restrictions. I've even seen examples of HOAs that require a specific sign where the realtor purchased that sign from a third party and the sign was identical, but because they didn't buy the sign from the HOA still issued a fine. And we've tried to introduce legislation in the past to address this. We don't have anything definitive yet. We had a small compromise that we reached with HOAs over the issue, but there is still some activity that's taking place. If you have any good stories to share with us that we can take to our legislative committee, I would love it. I would love to slam these. Maybe that's being a little too harsh. I just think there's too much overreach by HOAs in general, and they should not be restricting our members' ability to do business in that general sense. Cynthia asks, are we adding escalation clause and appraisal gap language to Form 391? No, not yet. We're going to take these ideas back to our forms committee, and it may be added, but they'll have to go through and review, and we'll let you know. We'll keep you updated on that. Matthew has another question. Matthew, go ahead and unmute yourself.
Sure. So I didn't want to put this all in chat. It's a little bit lengthy, but curious. I've heard it 2 or 3 times now of a new style of brokering and going after listings where a listing or a company as a whole would actually pay a possible seller for the first right to list their property. And then if something happens down the road or whatever, then liens are filed from that. And so I'm trying to get the clear cut, whether this is a violation of South Carolina law and things going on, because we are seeing this a little bit more coming up.
Just on the surface of what you said, a listing company that entices or solicits the listing, and there's a financial transaction involved in that, generally the answer would be that that is a legal process in South Carolina. I don't see why a listing company, I don't know of any statutory provision that would prevent a listing company from offering compensation to a seller. Now on the back end of the deal, Matthew, you mentioned, I think I heard you say placing liens on the property and things like that. Now I don't know if while that might not be illegal, I don't know that a seller would necessarily want to agree to a situation like that. Normally, discounts, rebates, things like that, offers of compensation are handled at the closing table once the property is closed. And we all know that as long as you're compensating the parties to the transaction through rebates or other things, that's certainly allowed by South Carolina law. So let's go offline and talk about that a little bit more, if you can send us some additional details. Allie asks, are we planning to update our commercial forms, specifically Form 331 and 225? I do know that the commercial forms are on the Forms Committee list, but I do not know the time frame in which those would be updated. So Allie, we'll get back to you on that. And Beth asked a question, can we add a closing date extension clause for addendums? And a loan change clause. So those are good ideas that we'll take back to the Forms Committee as well. Thank you, Beth. All right. We are getting close to the top of the hour here, and we really appreciate everyone's time. Any final thoughts or questions? Was this a valuable session? Did y'all like the opportunity to kind of chat with us for a few minutes? I'd like to do these quarterly and stay in touch so we can know what's going on in the marketplace and hear from y'all as well. Thank you for the kind remarks I'm seeing in the chat. If you didn't think this was useful, email me direct and let me know why, and let me know how we can improve it for the next time. So, Mike, I think we've got this wrapped up. So on behalf of Byron and Tiara and all the staff here at SCR, I want to thank you for joining us today. I hope that you are having a great spring and summer season. We look forward to catching up with you with our next legal update. In the meantime, stay safe, stay realtor strong, and we'll see you again real soon. Take care, everybody. Thank you.
Thank you.